Well, welcome to the next edition of Business Law Focus. It's great having you with us, and it's an absolute pleasure to welcome Fritz Milan and Jan Norval from ENS Africa. They're both labor experts, and we want to delve into progress, developments, gaps, what needs to happen when it comes to labor law reform. A really big issue, a critical issue. We're trying to get this economic engine working, and reform of South Africa's labor laws is often referenced as a key avenue to stimulate this job creation that's so desperately needed in South Africa, and also to improve investment opportunities. So maybe if I can start with you, Fritz, and I saw a really interesting online poll by your firm where 85% of the respondents actually said yes for labor law reform. Was that quite a surprise that it was that high for you, Fritz?
Even I think it's not surprising, because I think there's been many studies that have highlighted and commentaries on the low levels of investment and growth in South Africa, that there is a difficulty with flexibility in terms of labor law. I think the difficulty is that there's very little movement at present in that regard. And I think that from a political perspective, in the run-up to national elections, it may also be particularly difficult to advance an agenda for changes to labor laws that, although potentially of significant ultimate benefit to society, may not necessarily be popular in the short term. The process of considering and adopting changes to labor legislation is also really by its nature quite slow, because it of course involves discussions at NEDLAC, and it's very difficult sometimes on contentious issues to achieve consensus in the short term. But the sheer scale of the unemployment crisis is of such a nature that it may yet force meaningful discussion. And it was interesting to me that COSATU specifically commented after the release of the latest, even worse unemployment statistics on what they considered to be the inaction of government in the face of the unemployment crisis. So although there may be differences on how best to address unemployment, there's probably broad consensus that the current course of action in terms of economic and legal policy is having very little success in changing the trajectory of the crisis as such.
Yeah, and of course you mentioned unemployment record highs recently in the quarterly stats, 35%, which is truly alarming.
Yes.
And Jan, possibly if I can bring you in over there, is it seems like it's a little bit out of control if you look at youth unemployment especially, but we may not even have reached the peak when it comes to the unemployment problem. This really indicates that what we're talking about here is absolutely critical, right?
I think that's the case. As you mentioned, in the last quarter of 2021, we saw 35.3% unemployment in South Africa, and the IMF has indicated that it could grow up to 38.6% by 2026. And with the World Economic Forum indicating that South Africa is ranked 129th out of 141 countries for flexibility in hiring and firing practices. Perhaps now is the time to look at labor law reform, and the World Economic Forum has highlighted this as an area where we could perhaps stimulate job creation. In June last year, they submitted a report looking at rebuilding jobs after the COVID-19 pandemic in South Africa, and suggested the suspension of labor regulations in South Africa to help rebuild jobs, but they never indicated what what labor regulations could change.
Yeah, no, good point. And I know we'll get to NEDLAC. Fritz mentioned NEDLAC. I know there are important discussions upcoming when it comes to corporate sector, but maybe let's delve into that briefly where, I always find it interesting if you look at the US. Unemployment, these weekly stats, always surprising on the downside, and you have less than 5% in total, but yet the US is renowned for very little retrenchment protection at all. And I know you've Fritz and Jan, both of you have had a look at retrenchment in some detail. You've written in Business Day recently as well. What should we look at when it comes to any loosening in retrenchment? Is that one area where we could get some movement?
Well, I think so, Evan, because there does seem to be considerable factual support at the international level for the notion that particularly the right sizing of a workforce is a positive factor in stimulating economic activity and ultimately job creation. And it may be that with the best intentions, there's simply been a misconception policy-making level, and maybe even amongst South African labour law fraternity, of how and why retrenchment comes about, which may then also lead to a failure to produce the right type of legislation to serve society. Because at the level of simple economic self-interest, employers, of course, need employees to be able to operate. So employers are simply not inclined to retrench employees that they, in fact, need to operate their business. Trying to force employers through restrictive retrenchment laws to keep employees that they may not need locks in efficiencies that do not help competitiveness of employers and our economy. And a very restrictive retrenchment regime may also create the perception of enhanced risk in terms of undertaking labor-intensive enterprises, which may then discourage international employers from selecting South Africa as an investment destination for those type of enterprises. So the idea that preventing retrenchments prevents unemployment may therefore simply be conceptually flawed and wrong. But what is most certainly true is that there's a need for further analysis in terms of understanding the problem, and maybe then looking at examples internationally like the US, where the protection that is less in terms of flexibility seems to be working for them in terms of creating jobs.
Yeah, and Jan, if you look at some of the decisions in the courts, and the the courts, the labour courts especially, it's something of a lottery when it comes to these decisions. And is that a kind of reflection of the intense complexity here that we're dealing with, where you have very difficult trade-offs, but also the law itself is not, it's not understood and simple enough to actually understand. How do we get around that?
So I think that businesses like certainty. And I think our current retrenchment laws specifically don't allow that certainty for retrenchment. It's a very common practice for businesses to retrench staff and 2 years later to still be litigating on that matter. And a business that is retrenching is 9 times out of 10 in some difficulty, and now for them to be litigating 2 years later is not in their interest, and it's not in the interest of employees as well to be litigating for such a long period after a retrenchment. So I think that what we want is a simplification of our retrenchment law, and I think we obtain simplification of our retrenchment law by creating certainty. And I think certainty can be obtained by considering a number of different avenues. The first is a pre-approval system, where before an employer implements a retrenchment, they need to get pre-approval from an authority with tight timelines set with that. So once the employer has this pre-approval for its retrenchment, it has certainty that there's no further litigation that will happen afterwards. Other areas that can be considered is the increasing of severance pay in order to avoid litigation. Because at the end of the day, 2 years down the line, if there has been litigation regarding retrenchment, it is normally impractical to reinstate those employees, and they are paid compensation in any event. So if employers are willing to pay more severance upfront in order to avoid this protracted litigation, they once again get certainty. And then the third option is with regards to small businesses. Our current retrenchment environment means that if you employ 2 people or if you employ 40 people, the retrenchment process is the same for you. And we can consider something that Australia has done, where for small businesses, they are not required to pay statutory severance pay. And there's simply a vetting of a standard form in relation to retrenchment there. So these processes of pre-approval, increased severance, vetting of forms for small businesses creates that certainty while allowing for the protection of employees.
Yeah, great. I mean, that's wonderful to hear all those options out there, because, of course, if you look at it in reality, when you ask a tribunal or a single individual to really second guess what is an operational rationale is a very slippery slope. So, any assistance that simplifies it and that gives these options, I can definitely see as a serious factor here. And if I can just move on to Fritz. So when we're looking at labor law reform, of course, we've got the minimum wage in South Africa, a little bit of controversy around that, obviously economic rationale behind it is obviously something that is debatable as well. But the imperative, of course, is to support people that are struggling and the lower paid workers. We've got a huge gap between the high and the low paid workers in South Africa. But has enough research, for instance, been done here? Are there ways that we can improve the way that a minimum wage is rolled out and has a positive impact?
Evan, I think that we probably are light on research. I think it's necessary to take a closer look at the issue because there seems to be lots of contradictory sounds in the market as to what the impact of minimum wages in particular can be. And I think particularly where we see that in recent times, and I think Jan might be able to comment on this, is the issue of the agricultural sector, where there seems to be a sense that the minimum wage could impact negatively, but I think the overall take might be that because there's such a low level of compliance, it does not necessarily have that impact in practice. So I do think that it's something that does require more research and understanding because it seems as if due to the different interest groups that drive the research, you don't get a very coherent picture of what the true impact of shifts in minimum wages is. I'm not sure if Jan has anything further on that score.
For me, the main thing with minimum wage is its enforcement. In November 2020, the UCT Development Policy Research Unit issued a study regarding the impact of minimum wages, and they indicated that it's not having any real impact. And the reason why it's not having any impact is because people aren't following minimum wage legislation. So in the context of wanting to create employment in South Africa, why are we legislating laws that aren't enforced but are a consideration which may negatively impact upon the employment of persons? So I think that minimum wage obviously is a consideration for employers before employing, but I think it's once again we are not simplifying our labor regulations, because if we are making regulations that aren't enforced, we aren't creating an environment that has certainty attached to it and is not going to assist in employing our large swathes of unemployed.
Yeah, I've heard talk also of things like a no dismissal policy during the first 12 months. I mean, is that practical as well?
I think what that does is that seeks to protect current employment. It doesn't seek to create employment. What we want to do is we want to make it as easy as possible for employers to employ people and to create for instance, 12-month no dismissal policy. We are implementing another consideration which may be a bar for employers employing people. So I think we must rather create incentives to hire and not create further considerations for employers which may dissuade them from hiring persons.
Yeah, no, that makes perfect sense. And of course, we've got NEDLAC negotiations coming up as well. Executive pay is one of the areas that obviously has to be looked at as well. But any other aspects that we can expect out of NEDLAC? I know also employment equity, of course, is now targeted on a sectoral basis. Do you expect any outcomes there that may be relevant to the business community?
Yes, I think in terms of immediate movement, it's again unlikely to be anything too radical. I think as far as executive pay is concerned, that's always a concern of the union movement in particular. Yep. But I think that the difficulty with regulating in that space is that levels of executive pay is largely driven by the market. And the peculiarity of our labor market is that whilst there is rampant unemployment on the one hand, there's also a shortage of high-level skills that drives up the price of management. And I don't think it's too apparent how one actually regulates there without creating difficulties in terms of the ability of the country as such to acquire and to retain management skill, because that is something that's obviously still central to your economic success in many ways. But there is a different but related debate that should perhaps be had at NEDLAC in relation to whether, given the significant wage gap that benefits executives, it would not be justifiable and, in fact, in the interest of society for executives to enjoy lesser dismissal protections as compared to other employees. And you might recall that there was an effort some years ago to introduce that type of arrangement, which founded, I think, at the end of the NEDLAC process. And given the significant impact that failures by executives to perform their duties has on a broader range of people. A system whereby perhaps the dismissal protection for executives at a substantive and procedural level is reduced if a set minimum indemnity is, for instance, paid, is perhaps a direction of thought which would be productive, and again is not inconsistent with some other examples in other parts of the world. So that's the type of thing that might find some purchase. But whether there will be anything radical coming out of those discussions is difficult to see at this point, particularly where we are in terms of the run-up to national elections and so forth. It might be politically difficult to make significant changes over this time.
And we're running out of time, but just very briefly, maybe both of you can just conclude on employment equity. And, the risk obviously for businesses that they lose compliance certificates, and there's a longer period now of compliance that's been spoken about. Maybe just give us a snapshot of what we can expect during the year when it comes to reform on that front.
Yes, I think the issue and the difficulty with employment equity legislation is, again, that the practical economic impact must be considered in order to avoid a self-defeating effect.
Yep.
Because the laudable transformational goals can be lost if the impact on the labor market is a negative one. Because to achieve the societal transformation that one seeks, is probably not easy to do in a low growth, low employment economic environment. So I think that a balanced and reasonable enforcement approach is probably going to be very important in these circumstances, because of course you have the piece of legislation that says what it says, but the enforcement approach from the enforcement authority very often determines in real terms what the impact is on the labor market and on employers. And again, enforceability is also a bit of a question, because in the past it has been notoriously difficult for the Department of Labor to expend the sort of resources that are needed to enforce this type of legislation effectively. But a fairly pragmatic and balanced and reasonable enforcement approach will probably be quite important to get the right effect out of the amended employment equity provisions.
Thanks very much. I think that sums it up. I think we've covered most of the ground. It's certainly a tough situation getting to, the measures in place. As you say, we need to have enforcement. We need to have better impact and outcomes. And it requires a balancing act. But I think it's a very important year lies ahead on the labor law front. So thanks very much for unpacking this. Great chatting to you.
Thank you very much.
Thanks for having us.